Let's think now about Chapter 11, How Civil Cases End. In this chapter, we'll address the topics of civil procedure, steps in a civil lawsuit, negotiations, settlements, and dispositions, dynamics of trial court dispositions, negotiating small claims, bargaining divorce cases, and winners and losers in civil cases. What is civil procedure? Well, civil procedure governs how non-criminal lawsuits are handled in courts. The rules of civil procedure are very different from criminal procedure. It covers more legal matters, it's less extensive due to because of due process guarantees, and during trial, the plaintiff must only prove the defendant guilty by a preponderance of the evidence, as opposed to beyond a reasonable doubt. Our civil procedure is rooted in English practices. English civil procedure during the initial development of American law was very formal. It encouraged lawyers to include every possible allegation in its initial pleading. A heavy focus on the procedure to follow in a case was so much so that cases were sometimes lost because of technicalities. However, American adaptations were made. Initially, Americans rejected the formalism of English practice, but over time, the American system became somewhat cumbersome. So the modern U.S. civil procedure began in 1938 with the adoption of the Federal Rules of Civil Procedure. It requires notice pleading, which focuses on sharing information with defendants. It also provides the facts of a case are determined by discovery, and its issues in the case are narrowed by a pretrial conference. The Federal Rules of Civil Procedure are relatively short, but there has been many judicial interpretations. 35 states have adapted the federal rules for local use. What are the steps in a civil lawsuit? Well, the purpose of civil procedure is the just and efficient resolution of disputes. Based on the guiding premise of due process of law, notice must be given to an individual being sued. There must be an opportunity for that individual to respond to the notice. Table 11.1 shows the steps of civil procedure: complaint and service, answer and discovery, motions and pretrial conference, settlement discussions, trial, and enforcing of judgments. What is a complaint? A civil case begins when a plaintiff files a complaint, a notification to the defendant that he or she is being sued and for what reason. The complaint states why the court has jurisdiction, it provides statements of fact, it states a cause of action, and provides for specific remedies. The formal notification to the defendant is referred to as service and often involves a summons, a notice informing the person that a lawsuit has been filed and that he or she should appear in a court at a certain time. It's often delivered by the local sheriff or an authorized private process server, though today e-serving is much more common. It can sometimes be difficult to deliver as defendants may go into hiding. The answer is the defendant's written account responding to the complaint. The Federal Rules of Civil Procedure allow for 20 days for an answer to be filed. Failure to respond may result in a motion for default judgment, which is a victory for the plaintiff. Common responses in an answer include denial, affirmative defenses, or counterclaims. The complaint and the answer together make up the pleadings, the formal written statements about a case. The pleadings can be amended during the course of a lawsuit as new information becomes available. Discovery involves the formal and informal exchange of information between the two sides in a lawsuit. It rests upon the philosophy that before trial, every party is entitled to the disclosure of relevant information, regardless of its source. It's counter to the idea that information should be privileged. It's designed to equip both sides fairly for trial. Privileged information reflects the idea that some information should be kept confidential. Courts recognize a lawyer-client privilege, a husband-wife privilege, a doctor-patient privilege, a clergy-penitent privilege, and a journalist-source privilege. All except lawyer-client privilege are considered to be qualified and not absolute privilege. What are different tools of discovery? Well, one is a deposition, the sworn testimony of a witness taken outside of a courtroom. If a person refuses to appear for a deposition, a subpoena might be issued. It provides information to both parties about the deposition. Another tool of discovery is production of documents. the voluntary sharing of all documents related to a case, and if the party refuses, a subpoena ducis tecum can be issued. A subpoena ducis tecum is a court order requiring the production of documents in a case. Another tool is an interrogatory. An interrogatory is a series of written questions from one side in a lawsuit to another. Lawyers use interrogatories to get answers to factual questions or to get an explanation of the other side's legal contentions. The tools of discovery are intended to allow both parties in a case to share information and to guarantee that a decision will be made based on the merits of the case. Let's think now about motions. A motion is a request that a judge make a certain ruling. There are a variety of motions. Some motions are dispositive, which grant a victory to one party over the other. One type is a summary judgment, which says a party should win even if the allegations by the other party are true. Pretrial conferences are when judges and lawyers get together to discuss matters associated with the pleadings, issues of fact and law, and so on. It may also be used to get the parties to try and reach an early settlement and avoid a costly trial. This table shows how civil cases are terminated. The vast majority of civil cases are settled or disposed by motion. Let's think now about enforcing judgments. The court's official decision in a lawsuit is called a judgment, a court order, or a decree. If a defendant does not voluntarily comply with a judgment, the plaintiff must take further steps. Permission to seize property or garnish wages are ways in which judgments can be enforced. Negotiations, settlements, and dispositions are part of approximately 95% of all civil cases filed in federal district court that are settled before trial. Negotiation is where the parties in a civil suit are able to reach a settlement. Settlements benefit the litigants and save the court system time and money. Evidence suggests that there are relatively few offers and counteroffers in the course of negotiations. The intensity varies by type of civil case. There are more negotiations in torts, less negotiations in divorce. The entire system expects parties to settle through negotiation. One study showed that lawyers spend approximately 10% of case time on settlement issues, which means that lawyers really aren't focused on the 90%, really aren't focused on that part of the issues that should be focused on negotiation and settlement, but instead spend 90% of their time on trial preparation, even though so few cases go to trial. Lawyers focus on obtaining the best possible settlement for their clients. That's best results negotiation. Appropriate results negotiation is when lawyers focus on getting an appropriate result given the alleged facts. This is less adversarial and is used when evidence and liability are agreed upon. Ritualistic negotiations are when lawyers for the parties go through the motions of negotiations, offers and counteroffers, but the disposition of the case appears obvious, but the system expects negotiating behavior. Settlement is obvious in a civil case, or plea bargaining negotiating in a criminal case. Another type of negotiation is ritualistic negotiations. This is where lawyers for the parties go through the motions of negotiation, offer, counteroffer, but the disposition of the case appears obvious. The system expects negotiating behavior, so you go through the ritual of negotiation. Settlement is obvious in some civil cases where plea bargaining negotiation occurs in criminal cases. This is what is referred to as ritualistic negotiation. The disposition of cases varies greatly by the substance of the claim that are raised. Settling tort cases is different than settling a divorce case. 1 million tort cases are filed in state courts every year, and only a few tort cases will be high profile enough to have public attention. Tort cases focus on liability. Settling a tort case includes liability of manufacturer's liability for defective products, negligence for service providers, liability decreased for plaintiffs who have not caused damage, and lower standard for proving defendant caused the damage. Some critics believe the expansion of liability has led to a litigation explosion. Most tort claims never become cases at all. Tort cases reflect procedural adjudication involving a lot of pretrial activity as if preparing for a trial, even though trial delays are common. Negotiations are conducted by experts, and most of the time tort cases settle. Jury trials are exceptionally rare in tort cases, but jury verdicts do set parameters for negotiations and settlements. Negotiation happens in the shadow of the law and in the shadow of the trial. Trials represent substantial costs, which all parties work to avoid, and the typical defendant is a large insurance company. Let's think now about negotiating small claims. Small claims cases constitute the large category of civil cases and involve debt collections or non-payment of goods, landlord-tenant disputes. It does not attract public attention very often and reflects routine administration in the courts. Many cases are settled before an actual trial occurs at all, and some cases will go to trial, but usually they're a bench trial where the parties make brief presentations and the judge asks certain questions and then makes his own judgment. Enforcing small claims judgments is a real problem. One study found that almost 50% of cases the defendant never paid the plaintiff as the damages that were owed. The law is typically clear once the facts are established, and trials tend to be very quick. One study showed less than 10 minutes long. Let's think now about bargaining in divorce cases. More than 1.3 million couples legally dissolve their marriages every year, which is quite sad. This results in a large number of family law cases like divorce or child custody, paternity, or adoption. Family law has changed drastically over the years. We currently live in a no-fault divorce system that does not require bad behavior by any one spouse. Standards for custody have changed as well. The law used to assume that women would be the better custodian for children, but now fathers are given some deference as well. Most property today is considered shared through community property law rather than going to the man. This is unique because a divorce case is unique because a legal judgment must be secured, and most divorce cases are simply routine administration. Bargaining in divorce cases means that most divorce agreements will come to a judge after the parties have arrived at a settlement. Diagnostic adjudication often occurs when the judge has to get involved in settling issues relating to children in custody. One study has shown that only 1/3 of women received no payment of child support that was issued by a judge. There's been a great deal of study focused on who wins in civil court. Repeat players are more likely to win, but is that because of their expertise or because of the law on which they base their claims? In divorce cases, it's been shown that men generally come out better than women. Small claims cases benefit businesses who use them regularly. In tort cases, big insurance companies have more resources and tend to win more than defense lawyers. There are real economic and social consequences of who wins and who loses in civil courts. In conclusion, civil procedure was adapted from English practices. The steps of a civil lawsuit help us analyze what happens during a dispute. Negotiation occurs in all lawsuits, and the goal is settlement. Understanding who wins and who loses in civil cases is important.